Okay, so we're going live right now on YouTube. So this is on authentic court orders. So what's an authentic court order? There's some requirements for an authentic court order. And let's look at a couple here first. This is one right here. This is one that I got. I call it a fake order. And it doesn't really matter what it says here, but notice that there's just a judge's signature, a fake judge actually. That's a fake judge. And we'll go through why that's fake. This is federal court.
He's not a judge.
That's right, it's not a judge.
Stop saying that.
It's the cook over there next door.
He's an administrative officer.
It's the cook over there next door.
Not a judge.
That's not a judge.
Right.
That's right. You have to understand that. You got to recognize it. You got to call them on it. Here's another one. This is a notice of deficiency in one of my cases as well. And notice how she attached some other stuff to that. But so this is the signature part, and I have to feed this thing through to the so YouTube gets it, and so this is the one for the other one, and as you can see, this is a notice of deficiency. What happened is I was filing criminal complaints into the federal court, into an old court case I had going on in federal court, and the judge opened a new case and sent me an order of deficiency telling me I had to pay the filing fee and file a lawsuit. And so that's been 2022, so that's been going on for a couple of years now, and I've done, this is like the 7th amended version because she didn't like them, they're too long, and so I thin them down a little bit and sent them back, and I did the Form 1020, and it's Carrie's procedure. And anyways, see, they're wanting the filing fee, the fake money. And I have an upcoming video about fake money, but so you notice there's no seal there. So that's not a judge, that's a bought and paid for clerk masquerading as a judge. And so now what we'll do is we'll go into the presentation. Those are a couple of orders. I've got an order in the presentation. Matter of fact, it's someone we all know that actually looks like a pretty legitimate order. But the problem is it got overturned on appeal because he challenged jurisdiction. This Dr. Joe. Anyways, let's go ahead with this. So this is about authentic court orders. Kangaroo Courts number 29, authentic court orders. So first of all, I'm not a liar. Well, I'm in a lawyer. No, I'm in a liar. You should never take my word for anything. You should always do your own research. I provided references to aid you in your research, but I don't know everything. I'm open to ideas. There's 4 types of people you'll meet in your life. There's the people who try to wake up the slaves. There's the slave masters. There's the people who have no idea they're slaves. And there's the people who like being slaves. Which one are you? Do you know for sure? Are you who you think you are? If you can see through the illusion, then you are the solution. If the people do not know their basic rights and freedoms, how can they know when or if their rights and freedoms are being infringed? And that's what I see the most, is people don't assert their basic constitutional rights. And those bought and paid for clerks masquerading as judges are not going to serve it for you. If there's any place you get your rights violated, it's in their so-called courts. Never forget the men who started this country were marijuana growing, whiskey drinking, tax evading rebels who left their beds at night to shoot at the cops. And if you think about it, that's exactly what was going on. Everybody was required. I've got some videos on the militia. Everybody was required to be armed. If you went to a public meeting without your arms, then you got a fine. All tyranny needs to gain a foothold is for people of good conscience to remain silent. I don't trust the government. I don't trust the medical, pharmaceutical, industrial complex. I don't trust the military industrial complex. I don't trust the mainstream media. I don't trust the bankster criminal cabal that owns the medical, pharmaceutical, industrial complex, the military industrial complex, or the mainstream media. If you call me a conspiracy theorist, I don't trust you. So are we doing this, or are we doing something else?
A black Toyota Tundra, they're wanting the vehicle to be moved so you can work on it. Does anybody have that? A black Toyota Tundra. With the maintenance guys,
Government is not reason, it's not eloquence, it is force. Like fire, it's a dangerous servant and a fearful master. Tyranny. You know, this is John Locke, Treatise of Two Governments. And so this is stuff our founding fathers were reading. Tyranny is the exercise of power beyond right, which nobody can have a right to. And this is making use of the power anyone has in his hands, not for the good of those who are under it, but for his own private separate advantage. When the governor, however entitled, makes not the law but his will, the rule, and his commands and actions are not directed to the preservation of the properties of his people, but to the satisfaction of his own ambition, revenge, covetousness, or any other irregular passion. 'Tis a mistake to think this fault only in monarchies. Other forms of government are liable to it as well as that. For wherever the power that is put in the hands for the government of the people and the preservation of their properties is applied to other ends and made use of to impoverish, harass, or subdue them to the arbitrary and irregular commands of those who have it, there it presently becomes tyranny, whether those that use it are one or many. And that's John Locke, Two Treatises of Government, Book 2, Chapter 18, Section 199 and Section 201. So this is the Authentication Act in 1790, passed by Congress in 1790, Chapter 11, an act to prescribe the mode in which public acts, records, and judicial proceedings in each state shall be authenticated so to take effect in every other state. Be it enacted by the Senate and House of Representatives of the United States and Congress assembled that the acts of the legislature of the several states shall be authenticated by having a seal of their respective states affixed thereto, that the records and judicial proceedings of the courts of any state shall be proved or admitted in any other court within the United States by the attestation of the clerk and the seal of the court annexed thereto. If there be a seal, together with a certificate of the judge, chief justice, or presiding magistrate, as the case may be, that the said attestation is in due form, and the said records and judicial proceedings authenticated as aforesaid, shall have such faith and credit given to them in every court within the United States as they have by law or usage in the courts of the state from whence said records are or shall be taken. So, and so then that's May 26, 1790. So to sum it up, it can be certified by the clerk. It's got to have a court seal. It can also have a signature of the judge or chief judge, but it's got to have a court seal no matter what. And so, sorry?
Also have to have specific language.
Sorry?
By the dignity of the state and whatever, it has to have certain language also.
Well, the actually, I'm not sure. Let's go back to what that act of Congress said. Well, it says in, I think it's Article 4, it says that the full faith and credit shall be given to every other state. So I think it's faith and credit is, but I'm not sure that that language has to be there. But it definitely has to have a seal and it has to have a signature of a judge. And,
Has to have the court's information.
well, yeah, of course, yeah. Anyways, this is one that actually I found that looks like it's pretty legitimate. Now, that one's kind of hard to read, but that one's actually issued in Victoria, here in Texas. You can see the seal, you can see the signatures of the judge. It's a warrant, actually. But and then there's the, let me see if I can probably find that and blow it up on my hard drive here. I've got it on my hard drive. It's kind of hard to find, though. I had trouble finding it last time. It'd be interesting. Anyways, it's Dr. Joe. They issued a warrant for his arrest. That's all been overturned now because he went and filed a bunch of challenges to jurisdiction into that case, and it went to the Court of Criminal Appeals, and they overturned it, and they threw all these lower courts. This judge in particular, they threw him under the bus, and so now Joe is busy working with Randy Kelton. They're setting him up for a lawsuit.
Did they arrest him?
Oh yeah, they did. Yeah.
Good.
Yeah. And but there's the court seal. This one looks like more legitimate than any other. I'm not sure what this is. Oh, I think that's the sheriff. When they arrested him, the sheriff returned it. It's a warrant, it has to be returned. So, and so when they arrested him, then they return it to the court and basically saying they've got him in their custody. So this one looks like it might be legitimate. It's got the court seal, it's got the judge's signature on it, and it's a warrant. Anyways.
Does it have to be in blue ink? Does that matter at all? The warrant?
Well, this is a picture. I don't think it matters. The Authentication Act didn't say what color ink, right? This is actually Carper versus Fitzgerald, U.S. Supreme Court case, 1887. No appeal lies to this court from an order of a circuit judge of the United States, sitting as a judge and not as a court. Did you know that? That's one of the ones that Paul sent me. This is actually a really short case. It's like a page, 2 pages. So it's a quick read. Anyways, this was over a habeas corpus. A judge had issued a habeas corpus again for releasing someone, and the sheriff appealed the habeas corpus, and the Court of Appeal and the Supreme Court said, you can't appeal it. There's no appeal. And once the judge releases him, he's released. And discharging a prisoner brought before him on a writ of habeas corpus, an order of the circuit judge of the Fourth Circuit made in Baltimore, Maryland, that a prisoner brought before him here in Richmond, Virginia, on a writ of habeas corpus shall be discharged as a proceeding before him as a judge, and not as sitting as a court. And it is not converted into a proceeding of the latter kind, and by further order of the papers in the case be filed in the Circuit Court of the United States of Richmond, and the order of discharge be recorded in that court. So the point being is that judges sit in their private capacity all the time. It's not as a court. And this is Book 21 of Corpus Juris Secundum, Courts. Section 2, a court can be a court of general jurisdiction. They presume they're all courts of general jurisdiction. A court can be a court of general jurisdiction for some purposes and a court of limited jurisdiction for other purposes. So that's when it's actually a court. When, therefore, a court of general jurisdiction proceeds under a special statute, well, you know, if you think about it, they always proceed under a special statute. Anyways, it becomes a court of limited jurisdiction for the purpose of such proceeding. So the point being is that always challenge jurisdiction, always. Accordingly, this is Book 20 of American Jurisprudence, second edition. Accordingly, where a court of general jurisdiction undertakes to carry out a special power, a decision made in the exercise of such power is treated as a ruling of a court of limited jurisdiction, and the presumption applicable to a court of general jurisdiction that it acted within the scope of its jurisdiction does not apply. So they know that they're putting on a charade. You know, it's a kangaroo court. They know that's what they're doing. And so then their presumptions are different too. Anyways, it is familiar law that when special statutory authority in derogation of common law is conferred on courts of general jurisdiction, such a court of general jurisdiction becomes quad hoc, a court of inferior or limited jurisdiction. And so, again, it's talking about inferior courts of limited jurisdiction. Actually, a better word is kangaroo court. I mean, if you're legitimately, they assault you with the Commerce Clause is what they do. And so if you're legitimately involved in commerce, but they just presume you are and railroad you, and most people have no idea what's going on. That's why I call it a kangaroo court. That's why this whole series of presentations is called kangaroo courts, because they're all kangaroo courts. A ministerial duty is one which is required by statute. Ministerial act is an act that a public officer is required to perform in a prescribed manner in obedience to the mandate of legal authority and without regard to his own judgment or opinion concerning such acts' propriety or impropriety when a given state of facts exists. Discretion, on the other hand, is the power conferred on public functionaries to act officially according to the dictates of their own judgment. So this is one of the things that I did recently. Randy Kelton suggested I had this Montague County sued me over property taxes, and I filed, over 100 criminal complaints into that case for multiple felonies. And of course, the judge never issues warrants, and that's actually a ministerial duty. So Randy suggested I did a motion to disqualify the judge, and I did a demand to disqualify the judge, is what I call it. I always call it a demand because I'm a man. I did a demand to disqualify the judge and filed it into the case. And the next thing you know, they got a new judge. And that was I did the demand to disqualify the judge last May or June. And so it's almost a year ago now. And then I noticed there was a new judge online. I went on the website, they had a new judge. So I had to get the judge's oath of office because I'm going to use their oath of office and break it up in their ass. And so I contacted the Secretary of State to get their oath of office, and their oath of office was done in July. So they were a brand new judge. I bet you they were appointed by the governor or something. Anyways, so Randy hit a home run there, and he told me what to do, and I did it, and I nailed it. And they didn't want to talk to me after that. They held a show trial in December, and and I didn't show up because it's a kangaroo court. I filed felony criminal complaints against the lawyers and everybody, and they all of a sudden the tax assessor people quit communicating with me. Haven't heard a peep out of them since like September. No more notices saying that the taxes are, adding on the current taxes with the old taxes, none of that stuff. And they held a show trial in December, just before, it was like the 15th of December, just before Christmas. And I didn't show up. And then in January, the clerk sends me a letter and says, there's an order issued in this case. If you want a copy, then you got to send me $5 and I'll send you a copy. And I figured, well, that's perfect. That means it's nothing to do with me. If it was something to do with me, they'd send it to me for free. And so I don't care what the order says. It's nothing to do with me. Anyways, so a ministerial duty. Okay, we already read that. So that's kangaroo court, trial by no evidence. Okay, it's what you admit. Okay, they're a bunch of thieves and pirates. They just throw some stuff out there, and if you admit it or don't dispute it, then you get railroaded. That's exactly what happens. Okay, if there's any place your rights are going to get violated, it's in their so-called courts, and so that's why I filed the felony criminal complaints, because that's a minor estate. Okay, under Title 31 of the Code of Federal Regulations, Section 363.6, there's a minor estate, a Treasury Direct minor estate account set up by the Treasury. Actually, the hospital securitizes your birth, and they issue a bond, and they file it with the Treasury, and it starts that minor estate account. And when you when you turn 18 years old, if you don't take control of the securities, and I have no idea how you do that, quite frankly, and I don't really care, because that's all under the regulations. Okay, regulations. If you look at Article 4, Section 3 of the Constitution, regulations are for other property of the United States. Okay, so that's their property. They're a bunch of thieves, and so I just break it off in their ass. It's all color of law. Yes, Fran, what did you want?
Back up to what you were saying just prior to this, because you didn't respond to that, because that would, you ended it. If you had responded, that would have started a whole new thing. So you did right not to respond.
Well, I didn't respond to the lawsuit because I had already sent the Montague County Tax Assessor Collector a notice and demand that set him up for felony criminal complaints. I told him the way it is. I told him I'm not the minor estate. I told him that I'm a man. It says right on the deed. When I transferred the land, it says right on the deed that I'm a man. And so then when I sent that notice and demand to him, I used that as evidence, because they got to know that's there. The county tax assessor knows it, and so does. So I sent it, and when I sent that out, I sent it to the county attorney, I sent it to the county clerk, and I sent it to the county treasurer. So all of those four know for sure, and I have proof because it's sent it by registered mail. And so they all got criminal complaints for multiple felonies, and then they're liars. Okay, I meant they're lawyers. No, I meant they're liars. They got them too, and there was a whole team of liars. There was like 4 or 5 liars in this law firm, and so they all got it, and there was like about 10 there was over 100 criminal complaints. Anyways, so what happened is, yeah, I already told you what happened. So I didn't argue. The issue is that am I subject to the tax, and they can only deal with their corporate fiction entity, and I'm a man. And so they're trying to enslave me. That's involuntary servitude. So I filed involuntary, that's 18 U.S.C. 2071 or 2073. I can't remember. That's they're trying to enslave me. They're trying to force me to work for them for nothing. And, I took the IRS to the Supreme Court back in 2007. And that's what I said there too. I took them and I said, this is involuntary servitude. I didn't bring up the felonies. But they don't want to talk to me now, and I kind of like it that way, They don't ask, I don't tell. Anyway, so it's a kangaroo court. You got to understand, it's warfare, okay? And you never ever tell the enemy what you're going to do. You just set them up and sandbag them. Anyways, the word administrative is not synonymous with the word executive. The word administrative connotes of or pertains to administration, especially management, as by managing or conducting or superintending the execution, application, or conduct of persons or things. Thus, administrative acts are those acts which are necessary to be done to carry out legislative policies and purposes already declared by the legislative body. In fact, it is common to use the two words in tandem. It is noted as significant that the act constituted in the court dispenses with trial by jury, a provision which is distinctly upheld in spite of the Seventh Amendment. With respect to the status of the court, the opinion concludes a duty to give decisions which are advisory only, and so without force, as judicial judgments may be laid on a legislative court, but not on a constitutional court established under Article 3. And that's Williams versus United States. Where a controversy is of such a character as to require the exercise of the judicial power defined by Article 3, jurisdiction thereof can be conferred only on courts established in virtue of that article, and Congress is without power to vest that judicial power in any other judicial tribunal, or of course in an executive officer or administrative or executive board, since they're incapable of receiving it. And that's further in Williams versus United States. So again, that's what they're doing, and that they don't have authority to make Article 3 rulings. Anything Article 3 is life, liberty, or property. Anything affecting your life, liberty, or property, they don't have authority. And so, and so then think about it. If they don't have that authority, then that's why they don't put a seal there. That's why they don't put a seal there, because it's not the court. It's the cook next door making stuff up. And so you just let them know that you're operating in your private capacity. I'm going to sue your ass off, and that kind of stuff. And so, anyways. So I have exclusive content available on howto.com. It's $9.99 a month plus videos for videos plus unlimited email consultations. But I'm not a liar. Well, I'm in an attorney. Now I'm in a liar. But I can tell you what I would do under certain circumstances and where to find the forms. The only power that the New World Order Satanists have over us is through fraud and deception, and my agenda is to expose it for all our benefit, but I cannot fight all the battles. Some of my exclusive content is an Arlington private information share, land deed training. I've got like 2 or 3 videos on that. Estoppel certificates training, foreclosure estoppel certificates training, corporate denial training, toll roads notice and demand training. Speaking of toll roads, I went and I travel on the toll road here all the time. And I did the Form 1020 with the Toll Road Authority, the North Texas Toll Road Authority. And I went, and anytime I do that, I invite the chief counsel, because I want to have a lawyer that I can hold their feet to the fire, right? So it's easy to find online. You just find out who their chief counsel is and make sure you send them a copy. And so I invited the chief counsel and put them into default. So there's 3 of them. You send them the Form 1020. It's Carrie's brilliant form. It's all Carrie's fault. But anyways, so you just tell me what to pay. I want to pay, and they'll never tell you. Only your lawyers can answer, okay? And they'll never tell you. And so then you send them a notice of default, and then a final notice of default saying, I don't owe you anything. And so then I filed a bar grievance against their chief counsel, and now they don't even send me bills. I go on the toll roads all the time around here, and they don't even send me bills. I get nothing from them. But it's interesting that when I go on the toll road in Austin, that's not the North Texas Toll Road Authority. That's a different authority. But it's the same billing company. They send me a bill. So, they're getting my license plate, and they just leave it alone. Anyways, don't get me going. So invoice training, notice of void judgment training, revocation of signature training, third-party witness training, federal habeas corpus training. Revocation of voter registration, criminal complaint training. I got 3 or 4 videos on that up there, and I'm doing some more. Lawsuit training, I got 1 video on that, and I need to do some more. Other training requests, I can do other training, but it's got to be something I can do that's within the scope of my channel about the law, and it's got to be something I haven't already done. And believe me, there's over 500 videos on YouTube that are up there about the law. Anyways, I've also got Northeast Private Information Share videos. I'm going to be going to the Northeast Private Information Share here in a couple of weeks. And all forms, files, and other instructions are available for free, linked on my videos or on my website. I have exclusive content available on HowTube, and you can buy a subscription there. And I have no control over HowTube, okay? I have absolutely no control over that. They do their own billing, and they send it to the account that I have set up. So, like when I had it on my website, I mean, I could take Bitcoin, I could take all sorts of stuff. I don't know what HowTube takes, but I have no control over it. Anyways, so when acting to enforce a statute and its subsequent amendments to the present date, a judge of municipal court is acting as an administrative officer. Remember, we're talking about that. It's not a superior court of general jurisdiction. It's an inferior court of limited jurisdiction. An administrative officer working for the executive branch. Not in a judicial capacity, courts administering and enforcing statutes do not act judicially, but merely ministerially, but merely act as an extension, as an agent, bought and paid for a clerk. Okay, they're basically a bought and paid for a clerk, not in a discretionary capacity. Oh, look at that, a bought and paid for a clerk. Judge works for the state, prosecutor works for the state, police or witness works for the state. The vast majority of the disputes that the police initiate on behalf of their employer are also adjudicated by their employer, where the plaintiff, the judge, the antagonist, the police, and the only witness, also the police, all represent the same party. And since no corpus delicti, mens rea, or acts reus can be produced, doesn't technically qualify to be heard according to its own laws. The state, therefore, is indistinguishable from a criminal cartel. And that's exactly what it is. It's an extortion racket. And that's why, if the cops think they're going to stop me, I start filing criminal complaints against them and their boss and the mayor and the city council. And we've already talked in other videos about how the mayor in Bedford got removed and, anyways. It is the accepted rule not only state courts, but the federal courts as well, that when a judge is enforcing administrative law, they're described as mere extensions of the administrative agency for superior reviewing purposes as a bought and paid for clerk. Law enforcement officers enforce statutes. Law enforcement officers are not peace officers. Law enforcement officers are operating in their private capacity. Oh, look, a kangaroo court. A bunch of kangaroos. Judges who become involved in enforcement of mere statutes, civil or criminal in nature, and otherwise act as mere clerks of the involved agency. Ministerial officers are incompetent to receive grants of judicial power from the legislatures. Their acts in attempting to exercise such powers are necessarily nullities. That's why they don't put the court seal on it, because they're not competent to act on behalf of the court. Think about it. Kangaroo court, guilty until proven innocent. The corrupt Star Chamber courts of England require defendants to have counsel. How many times do they want to assault you with one of their liars? Well, I meant one of their lawyers. No, one of their liars. Star Chamber stood for swiftness and arbitrary power. It's a limitation on the common law. International law rule, adopted for areas under federal legislative jurisdiction, federalizes state civil law, including common law. It's all international law. If you think about it, you're under the Commerce Clause. It's all Article 1, Section 8, Clause 3. They're bringing the District of Columbia outside of 10 miles square in violation of Article 1, Section 8, Clause 17. Anyways, federalizes state civil law, including common law. The rule serves to federalize not only statutory, but the common law of a state. state and federal venue, discuss the civil laws effective in an area of exclusive federal jurisdiction or federal law, notwithstanding their derivation from state laws, and a cause arising under such laws may be brought in or removed to federal district court under sections 24 and 28 of the formal judicial code, now sections 1331 and 1441 of title 28, giving jurisdiction to such courts as civil actions arising under the laws of the United States. Okay, again, but these courts, and I'm doing a video on this, they're all commerce. They're all commercial courts. And it's interesting that this guy here said that they had actually admitted that it's not an agency of the government. And so they're just a bunch of pirates, thieves. This is taken from a report of an Interdepartmental Committee of the Study of Jurisdiction of Federal Areas Within the States, Part 2, a text of the Law of Legislative Jurisdiction, submitted to the Attorney General and transmitted to the President June 1957. And this is taken from pages 158 to 165. So, I mean, those books are easily found online. You just do a search for them, and there's two books. One's about 400 pages, and the other one's about 600 pages. And they're easily found online. Oh, look, another kangaroo court. We find the president guilty. Now let the trial begin. Yeah, it's prejudged. It's exactly the way they do it. The United States District Court is not a true United States court established under the Constitution, Article 3, to administer the judicial power of the United States, but was created in virtue of the sovereign congressional faculty granted on Article 4, Section 3, making all needful rules and regulations respecting the territory belonging to the United States. This is actually Texas Judiciary Courts of the State of Texas. Is kind of hard to read, so I'm not going to spend a lot of time on this. But if you want, I can send you a PDF of this. This is the Judiciary Courts of the State of Texas. And this is talking about the Dun & Bradstreet printout, set up in 1845. Anyways, it's kind of hard to read, so I'm just going to skip right on past it. So there's no Article 3 courts. In 1861, the southern states walked out of Congress. Congress ceased to have a quorum. Lincoln ordered them back under executive authority. In 1871, they set up a corporation domiciled in the District of Columbia called United States. And that's what's operating. Since then, Congress has been operating under executive authority, no lawful authority. Remember recently, Texas sued over election fraud. Remember that? And the Supreme Court sent an unsigned document back saying we see no justiciable issue. Well, think about what they're saying. Okay, think about what they're saying. They're saying that if you, first of all, when you register to vote, you swear under penalty of perjury you're a U.S. citizen. Okay, U.S. citizen is the District of Columbia. So these elections that you see going on are District of Columbia elections. And they're saying to Texas, what's Texas got to do to say about a District of Columbia election? They have nothing to say about how District of Columbia operates their elections. This is a District of Columbia election. It's corporate. It's all corporate. So Texas doesn't have any. It's not a lawful de jure election. Anyways, don't get me going. Don't forget to subscribe to this YouTube channel. Don't forget to follow me on Steemit. Don't forget to like this video on YouTube. Don't forget to click the bell next to the subscribe button so you're notified when there's a new upload. On Steemit, don't forget to vote and make your comments. That's the front page of my YouTube channel. The arrow is pointing at the bell. The subscribe button's already clicked. That's why it's not red. The bell needs to be clicked and it'll look like it's vibrating. This is the same thing that's been going on that precipitated the War of Independence. This is taken from the Cause of Necessities for Taking Up Arms, passed by the Continental Congress in 1775. And it's like about 4 pages, so this is, some of it. Statutes have been passed extending the courts of admiralty and vice admiralty far beyond their ancient limits for depriving us of the accustomed estimable privilege of trial by jury in cases affecting both life and property, to supersede the course of common law, and instead thereof to publish and order the use and exercise of the law martial. Okay, gee, that sounds like martial law. And for altering fundamentally the form of government established by charter, we saw the misery to which such despotism, okay, that's dictatorship, would reduce us, okay? Trial by jury. The War of Independence was fought over the denial of trial by jury, okay? And none of us ever bring that up. And anytime somebody brings it up and stands their ground, the case goes away. This is the Declaration of Independence. I think I'm going to skip some of this. I think what I'm going to do, actually, is I got to use the restroom. So I think I'm going to stop everything. And what we can do, I got some comments here. YouTube is live, yep. I'm looking here. Anyone else have an echo? In Texas, trial by jury puts evidence in the law and judgment. Needs signature of the county clerk. I think what I'm going to do is I'm going to end the live stream right now. And what we'll do is we will, I'll finish this thing online and do it, or maybe we'll do it next week or something like that. Anyways, there's another, let's see, how many more slides is there? And I got to use the restroom. It's one thing about that T. This is at 45, and we have about another 50 or 60 slides to go. So I think we should probably end it right now. And so thanks everybody for watching online.